This is the next installment of our video series related to why South Dakota is the best trust jurisdiction in the United States. And today we're going to focus on what's called special purpose entities. So let's get into it. All right, so special purpose entities, or SPEs as people often refer to them as, are very, very unique, exclusively unique to South Dakota. People do use the phrase SPE or special purpose entities generically, but SPEs are something that is actually on the books in the laws of South Dakota, and it's used specifically for the purpose of trust planning. So if you watched any of the other videos that I've done in this installment, we've talked about Trust Protector, we've talked about the directed trust model, which is also other reasons why South Dakota is so favorable. And then you've realized we have a lot of flexibility. We part and parcel out these different responsibilities regarding the administration and management of the trust. But there's this additional strategy that we can implement with the SPEs, where rather than naming individuals in these various roles, we can name the SPE. The SPE is an LLC that is established under the laws of South Dakota. It's registered in South Dakota. It is registered with the banking division of South Dakota, and its purpose is twofold. So first one is to limit the personal liability that the investment advisor, the distribution advisor, and the trust protector as individuals would have. So now all of a sudden you name an entity in those various roles. And then in the operating agreement of that SPE, you specify who's going to be in charge of the different roles. Okay, so the trust protector, investment advisor, distribution advisor, etc. Or there's different ways to approach it, but this is the general idea. So rather than naming the individuals, you name the entity. That shields the individuals from any personal liability from acting in those roles. That's really, really important, especially if you name your accountant, your attorney, your financial advisor, one of your professional advisors in these various roles. This gives them an additional level of liability protection that they probably want when serving in this role. Okay, so that's the first thing. And I think the second one is probably more interesting to the client. And the second one is that it is an additional tie to South Dakota, to the jurisdiction of South Dakota. So let's just say you're a California client and you've set up your trust in South Dakota, and then you're naming people that you know in the investment advisor, distribution advisor, trust protector roles, and those people are located in, say, California. Then the trust now does have some ties, some connection to California. And the idea behind setting up the trust in South Dakota is that you sever all ties to California. The way to do this a step further, to completely remove the administration aspect of the trust being administered in that state where the distribution, investment advisor, or trust protector is located, is to include the SPE. Now, all of a sudden, you've completely removed the ability to tie the trust back to another state. Everything regarding the administration process is located in South Dakota. So when it comes to income tax avoidance, state income tax avoidance, and when it comes to asset protection, having everything done under the jurisdiction of South Dakota is what is most beneficial. It's going to maximize your benefit under asset protection and state income tax planning. So it's the SPE. There's no other state that offers some type of similar structure that protects the different people in these roles and allows you to sever the jurisdiction tied to whatever state that they're located in.